Started. Thank you. Perfect. All right. Welcome, everyone. As a reminder, you can turn captions on. If you look at the bottom of your Zoom window, there should be a show captions icon. Please, if you have questions for the presenter, put them in the Q&A. And we will get started. So thank you to Wilhelmina Randtke, the head of Library Technologies and Systems at Georgia Southern University Libraries. She'll be talking about copyright law and artificial intelligence, current U.S. regulation, ethical considerations, and impact on licensing trends.
Okay, so I'm Wilhelmina Randtke, and today talking about copyright law and artificial intelligence, although also the subtitle is about U.S. regulation and perhaps copyright as a tiny slice of that, or even watch the hand where it may be used to manipulate other aspects of regulation. That is the abstract, so that when this is online, people have the abstract. Um, First off, here's a little background on what generative artificial intelligence is. Um, Artificial intelligence is a term where there isn't a set meaning. Past definitions have involved expert systems where software takes a decision tree and applies that. The current buzz about generative artificial intelligence is where an algorithm processes large amounts of data, trains on that data, and finds patterns in it, and then builds out in response to those patterns, then uses those patterns embedded in itself to generate additional output. Today, when we're talking about artificial intelligence, we're probably talking about generative artificial intelligence because that's been the buzzword for the past couple of years. In ChatGPT, the GPT stands for Generative Pre-trained Transformer, and so generative and pre-training are part of that concept. Machine learning is a field of artificial intelligence focused on designing computer systems that can automatically learn and improve based on data. Generative artificial intelligence relies on a subset of machine learning that builds models using neural networks. And a neural network is an algorithm that maps input to output. The mappings change based on seeing examples. So seeing examples in a set of training data. The algorithm before training and the algorithm after training are different. For example, GPT-3 used by ChatGPT version 3, they have the actual like untrained algorithm on GitHub, but is not trained, so it's not like you can take it and run it. The training process is where it looks at lots and lots of examples, so lots of websites, video, images, full text books, whatever you have it look at, uses that to determine how it will map input to output. And then after being trained, it has mathematical modeling for the relationships between different concepts and uses that to generate output. The training process involves huge amounts of resource input, so lots and lots of electricity. It's typically done on computer clusters that are connected chips where it's not just like a graphics card you could buy at the store. Instead, they're like um, much more expensive, like $10,000 to $40,000 processing units where it's several hundred of them together. And then it takes lots and lots of textual or image or video input depending on what's being used to train it. So that's where what is powering chatbots and image generators is lots and lots of inputs in the real world and lots of intellectual or content inputs. There are two older concepts which are similar. So the concept of analyzing a whole lot of data and then making a prediction that's similar to an older buzzword. Big data was a buzzword about 10 years ago, and then text mining was a buzzword from about 20 years ago. One of the differences or trends is that those would have been not maybe training an algorithm and then having an output, but where there's actual statistical function run on the input, and then there's an output based on like the analysis is complicated mathematically, but it's not like there is a trained algorithm and untrained algorithm. But then another difference is what they're ingesting and what they're outputting might be moving more from ingesting facts or statistical information, which would be the case with big data, to current generative artificial intelligence is ingesting novels, photos, and art and more expressive content. And then with outputting, it might be the case that in the past, text mining and big data had been focused on outputting a statistic or something more like a statistic factual item, whereas perhaps generative artificial intelligence are outputting expressive content. The current generative artificial intelligences, they can be used to say, like, here's a recommendation for a decision. So they can be implemented for decision making where they're just doing almost like a single statistic, but also a lot of what has captured popular imagination is that they're writing like paragraphs or making it picture. Um, so text mining, big data, and generative artificial intelligence are on a continuum as far as technology goes, but then the real world outputs and inputs change in a way that makes copyright more of an issue. A lot of the legal analysis around text mining was in a context where the technology was outputting statistical analysis, while current generative artificial intelligence is outputting more like conversational paragraphs and longer form material. So, this is a little bit about copyrightable subject matter. Copyright applies to original works of expression and does not apply to mechanical, non-selective compilation of facts. So the case at the bottom side is Feist versus Rural Telephone Service Company. And basically, you can't copyright the phone book, or at least the phone book is not copyrightable subject matter. Um, in moving along that continuum with the inputs and outputs becoming more expressive and less like statistics, the training process might eventually deviate from big data and text mining and conceptually what data is being worked with to become more expressive. So that's one difference from the past. The other difference is that the concept of the trained algorithm versus having the actual inputs there. Little more background about copyright is these are the fair use factors. Those are written into Title 17, Section 107 of the United States Code. Purpose and character of use, nature of the copyrighted work, amount and substantiality of the portion taken, and effective use upon the potential market, especially with taking expressive work and making other expressive work. It might be that the effect on the market is different from text mining. Nevertheless, as far as case law and lawsuits go, um, in court has a trial court level and then various levels of appellate court. Only decisions of appeals courts are binding on anyone else. With generative artificial intelligence, there are some lawsuits over the training process, but so far those are at the trial court level, or at least there haven't been an appeals decision. At the very end, there's one of them is up for appeal. So there will be an appeals decision, which may or may not get to whether training makes any kind of difference. But really, the binding case law for generative artificial intelligence copyright is the fair use analysis. And the fair use analysis of text mining is what's most relevant. Text mining would typically involve analyzing expressive content, maybe with statistical output as the goal. It's generally been found to be an acceptable fair use, but once again, it also in the past has had statistical output as the goal. The key legal case for that was the Google Books lawsuit, Authors Guild versus Google, about scanning lots and lots of full text books to make a search engine for books and make the Ngram viewer. So make a statistical analysis tool and then a search engine where you could use it, and then actually you would go and get the book. You can't click through to most of the books in it. With text mining, the copyright and licensing issue has been that text mining is generally accepted as a fair use and it's not prohibited by United States copyright law. And then once that was established, many database companies inserted restrictions against text mining into the licensing terms, such that someone accessing under the license had contracted away that right. The controversy in the library community about text mining has historically been about license terms on electronic databases clawing back and prohibiting an otherwise allowed use. And the discussion around text mining in the library community might historically have been about how to ensure researchers are able to continue to do that, and how to not let database companies contractually preclude this form of research. Going back to court cases about copyright law and artificial intelligence, the key binding law that's core to case law is about fair use. So just to think through issues, the best way is to look for an overview of what fair use covers now and to dive a little deeper into discussions about text mining. That's what the binding law is at this time. The open issue right now probably is that some of the inputs and outputs have shifted away from statistical and towards more expressive content, especially more expressive output that competes in the same market. Now let's take a look at artificial intelligence regulation in the United States at a broad level. This is all the regulation for artificial intelligence across the whole United States, of which copyright is a tiny little sliver. Um, that is a timeline of artificial intelligence regulation in the United States, so comprehensive. It has a lot of detail. The slides are posted on the shed, so you could get it and actually click in and read these. But it's basically the key documents for the overall process of regulating artificial intelligence. And it's the whole big picture. Something important for understanding the background of artificial intelligence in the United States is in the US, the two biggest funding sources for artificial intelligence research are Department of Defense funding for autonomous warfare, and then corporations looking at how to make money with artificial intelligence. The Department of Defense has money in its budget every year for prototyping, which is pretty flexible, and that's where it funded artificial intelligence for many, many years. So going back before this timeline and way before this timeline. And that is essentially why the two US laws in here are Department of Defense funding bills and why comprehensive rollout for a federal policy for artificial intelligence is a portion of a Department of Defense funding bill. Three things about it are it has a lot of detail. The most important thing on here is the January 2021 National Artificial Intelligence Initiative Act of 2020. It has a plan for a 5-year rollout of artificial intelligence regulation across federal government. It includes funding. So because it's funded, there's a lot of activity in response to that. That rollout plan was not to do X, Y, Z and regulate in this exact way. Instead, it was to consider a list of issues and then have milestones for each agency to develop a cohesive federal policy for artificial intelligence regulation. That included ethical issues related to artificial intelligence. That's probably the most impactful thing because funded. The next thing to notice about the timeline is even though government right now is volatile, and maybe what happened over the past 4 years might have less continuity, this specific regulation was an initiative of the first Trump presidency. So maybe there's more continuity for artificial intelligence regulation. Even the November 2023 executive order for all agencies to well, it focused heavily on mitigating bias in artificial intelligence or for all agencies to do that. It's now rescinded, but it had a deadline for agencies to complete all their activity by October 2024, and it was rescinded January 2025. So by the time it was rescinded, essentially activity under it would have been completed. There is a later executive order from the current president that addresses it. So that January 2025 one, it just says undo things if they're a threat to national security. It doesn't say go back and tease out what was done as part of this executive order versus part of the 5-year rollout from the National Artificial Intelligence Initiative Act. Instead, it says only if it's a threat to national security. So there is a lot of continuity in the federal government, and probably this is a more predictable policy area where there's going to be like just continuity and not a lot of sea changes. So those are the key points. There's comprehensive nationwide regulation with continuity since 2019. There's a funded 5-year rollout starting in 2021, so in fiscal year 2021. And then ethics is part of that comprehensive artificial intelligence regulation, along with other things. So now for the United States Copyright Office. The Copyright Office, as part of implementing the National Artificial Intelligence Initiative Act during 2023 and 2024, took public comment on a series of questions about artificial intelligence and copyright and held public meetings. As follow-up to issues raised and information provided in that process, the Copyright Office is releasing an artificial intelligence report. So far, they've released 3 parts. They haven't officially said how many parts there will be and what each will be named or what the topics will be. But the introduction to part 1, reproduced here, gives the list of topics. Part 1 was about digital replicas, and the introduction to part 1 said that future parts would include copyrightability of works created using generative artificial intelligence, the training process for copyrighted works and training on copyrighted works, and then licensing considerations and allocation of potential liability. So far in parts 2 and 3, they have followed those topics. So what might be coming next is licensing and then allocation of potential liability. Part 3 has a significantly long section on licensing, so that might already be addressed and there might not be a separate report. And this in the slides, which are on the shed, links to those reports so you could get them. What those are useful for um, is a lot of jumping off points and factual backing. So I love government documents because they have lots of citations and they're usually about saying how things are rather than advocacy or having some kind of thesis. So a book or article might have an argument for why things should be a certain way. Usually, government reports are pragmatically describing how things are. And you can see here that the whole report has like lots of citations and lots of jumping off points. So this is just a random 2-page spread right at the beginning of the first report or the first part of the report, but a lot of it is cited to this level of detail. For these Copyright Office reports, you could pull one, look for a relevant section, and then have an accurate summary of what the law looks like for that right now in the US and what kind of factual issues were raised in the public comment. Some of the findings from those reports are regarding whether output from an artificial intelligence system can be copyrightable subject matter. Probably not. So this was an example given in the part 2 of the report. The parts labeled prompt and input is what somebody put into a generative artificial intelligence system, and the output is what came out. The Copyright Office, so in quotes, their what they allowed to be registered from that was limited to the sketch and the written prompt, but not the computer generated one. So if somebody made a copy of this one, that would be infringement to the extent that it's the same as this, but it wouldn't be infringement to the extent that it's the same of this. So if somebody took the computer generated portions of this, it would be like, how similar is it to that? So essentially, output from a computer generated system is not copyrightable subject matter. It's more the portions of what the person put in that all came out. Um, then regarding training on copyrighted material or material subject to copyright, the conclusion for the part 3 report was that making commercial use of vast troves of copyrighted works to produce expressive content that competes with them in existing markets, especially where this is accomplished through illegal access, goes beyond established fair use boundaries. So in text mining, a lot of why that's allowed is that the outputs of text mining are usually different than they're not expressive content. So the output being expressive content and then competing in existing markets could move things along the fair use continuum or make things not be a fair use. So it's not really surprising, but there is at least guidance and it's backed up by a long detailed report that goes into law and then has like statistical information from stakeholders that they submitted. Going back to artificial intelligence ethics, going into that timeline of artificial intelligence regulation, a common thread through a lot of this legal activity is ethics regulation. The National Artificial Intelligence Act includes provisions about ethics across federal agencies, um, and it's an appropriations package. Then the executive orders keep going back to like trustworthy. Um, so there is an ethical or the idea of regulating ethics in artificial intelligence is part of that. In the wider artificial intelligence technology community, fairness, accountability, transparency is the theme of a long-running Association for Computing Machinery conference about technology ethics. And that is a framework for assessing ethics in technology. A good way to approach ethical issues is to look at whether an approach is accounting for all of those. So for all three of fairness, accountability, and transparency at the same time. With copyright, two ways that ethics might be co-opted are, first, stakeholders could say that licensing agreements solve ethical problems with training. Um, that overlooks bias issues, it overlooks harms to people when a system is applied to them, and it sidesteps explaining why a system is doing what it's doing. There might be an incentive for some stakeholders to focus on licensing and to try to make the ethics conversation be about licensing as a watch the hand to detract from more serious issues or from serious existing issues. Or to say that if they license all their content and swear that they licensed everything this was trained on, that satisfies transparency because everything is so ethically licensed and so great. Um, and to say that that gives a blessing to the entire training process. So some stakeholders might try to make the ethics conversation be limited or be about copyright instead of being about fairness, accountability, and transparency. Second, large corporations operating artificial intelligence algorithms have already made the argument that it is necessary to collect information about diverse communities in order to eliminate bias, and have used that argument to justify surveillance of marginalized communities. So when collecting all kinds of written and visual material into a training data set without any form of consent, that's the same kind of violation. In statements filed with the United States Copyright Office about licensing, for example, this same argument about needing to eliminate bias with a diverse training data set is used to argue against licensing schemes which would allow a creator to opt out. Significantly, that's not to argue against licensing schemes, that's to argue against individual people being able to opt out. Licensing deals will be done with aggregators and not individuals just because logistically that's what has to happen. And this eliminating bias argument could be used to prevent opt out by individual creators. We're librarians, and so we might be more interested in the copyright aspects of artificial intelligence, but also if you're thinking about ethics, try to think about fairness, accountability, transparency, and think about what might be missing from the picture in a conversation. And then finally, copyright law in the US is about economics. It's not about an ethical issue. So that is the copyright clause from the US Constitution. The purpose of copyright is to incentivize creators to keep creating. It's not really about like people's rights to own something. It's just an economic thing. So it's not really ethically grounded in the US anyway. Um, Now, there is one court case up for appeal. When I submitted this, nothing was up for appeal. So first off, in court, there's a trial court level, then appeals courts. Only appeals court opinions are binding, although if trial courts tend to do something, that might mean that there's something else that is going on, like it's real clear cut. That court case is Westlaw versus or Thomson Reuters versus Ross Intelligence. Ross Intelligence was a legal research tool which let users type a question. It had been trained on legal cases with head notes and key numbers from West Publishing the training data. Head notes are controlled subject headings, and those are like this is a screenshot of a case. The headnotes are usually copy pasted from the case, so it's almost like if you took and printed out and highlighted the important points. And then the headnotes is a controlled subject heading, but it's real detailed. So this is a screenshot of a different case, but you can see how detailed it gets. Oh, just so pretty detailed information. Um, Ross Intelligence was trained on those with an actual generative artificial intelligence training process. So it was trained on a small set of cases, including essentially headnotes and keynotes from West, or from Westlaw. So the appeal, because there has been at the lower court level, trial court, summary judgment granted to Westlaw, the appeals on two things. So first off, whether the subject headings can even be copyrightable subject matter, which is close. And then whether incorporating subject headings into training data can be an infringement as part of it. So a copy of the headnotes and key numbers wasn't permanently kept, and so it was used for training, and then the train algorithm was retained, and that might or might not be part of the decision. That went up for appeal in February, and so soon there will be a case about it. Things about this that are kind of interesting is Thomson Reuters is a really huge company. Ross Intelligence is a smaller company. I think that they are now no longer in business, even though they still have a website. Um, then with the law, we're all subject to law, so we have a right to know what it is. Um, the court cases with the indexing information, the court cases are public domain. It's just the indexing information. So selecting what parts to sort of highlight, like what quotes, and then assigning subject headings. Um, and then so the copyrightable subject matter is descriptive metadata. So it's kind of interesting in that in some of the other areas, it's perhaps not like starving artists, it's more factual information or close to public domain information. But it is the first time that there will be a published court opinion about something that used training data or that training process. Um, that is it. Do people have questions? And I hope so. And I have references too.
Thank you. That was, well, for me, a lot to digest. Oh, we do have a question. What was the original court trial ruling?
So a little bit about it is this is going way back. So Ross Intelligence launched in 2014 when they had where one of their features was not just a search engine, but people could type in a question and then have a memo answering that question emailed to them later. That was live at least by 2018, and they were sued in 2020. There has been back and forth, but it was a summary judgment motion by Thomson Reuters. Summary judgment means that there is no issue of law or fact, or sorry, no issue of fact to send to a jury. And there were two things in there. So first, it's whether or not the keynote system is copyrightable subject matter. The trial court judge says it is, and it is a very detailed system of indexing. The second was whether training on the headnotes and keynotes was copyright infringement, and the summary judgment was that yes, it is, and this is very clear cut. So that's what will get appealed. There are also some of what is going on is that there's a free law movement in the US to have more access to legal research tools for regular people, and there's some interest from that community in the case.
Thank you. We have another question. What are your thoughts on the current bill and AI issues in it?
What's the current bill? Like, can you just type a little bit? Oh, so I I'm a little bit curious, if you have like a name or something. So they're part of the National Artificial Intelligence Initiative Act is that it directs agency or it directs there to be developed a comprehensive federal policy, but then it would be put into regulation. Oh, so Maria asked, do you have any recommendations for how to stay up to date on the topics of copyright plus artificial intelligence, especially given how long some of the cases seem to go on for? Um, I've been monitoring federalregister.gov and I'll search it like every 3 months or so to see if there's like that's where people put their upcoming regulations, but it's not super easy to navigate. I would actually say that checking Wikipedia for key court cases about fair use is one way that you could do it. So for example, anything that has gone to the United States Supreme Court is going to have probably a pretty good Wikipedia page. And if you were to look at history and see, like, are there changes? So for example, in the Google Books case, and a lot of it is there are current information tools for legal research, but a lot of them are very expensive.
We have another question. Very early days, but do you have any thoughts on potential impact of possible changes at the Copyright Office?
Um, I don't know other than that, the reports were the outcome of like a 2-year notice and comment period, which is like the Copyright Office would post maybe like series of 20 questions and give 3 months or 60 days to answer those. And all kind of industry groups would file answers. So like you could file an answer, like Creative Commons would file statements on them. Large tech companies like Meta and would file comments on those. Having a change in staffing likely would make writing the parts 4 and 5 of the report somewhat difficult because of the time to come up to speed in assessing all of the information. So the changes probably will slow the rate of policy.
So Liz has shared the part two, artificial intelligence and information technology modernization, section 43201, artificial intelligence and information technology modernization initiative, subsection C, which states that no state or political subdivision may enforce any law or regulation regulating artificial intelligence models, artificial intelligence systems, or automated decision systems during the 10-year period beginning on the date of the enactment of this act.
So what they're trying to do is make it to where if one state regulates, then like a company trying to operate nationwide has to navigate every single state. But I don't know if they can do that because the federal constitution states have to agree to it, and there is something called the Uniform Law Commission, which is just a trade group, but it has like retired Supreme Court judges, so it's not really just a trade group. They will do like uniform laws about things, and then typically if they do a uniform law, states will adopt it. So for example, child support, there's a uniform, it's UCCCJ, but I don't remember what it stands for. There's a uniform calculation for child support that was adopted in the 1960s and has been adopted by like all 50 states, so that if somebody crosses state lines, they can't forum shop and have an argument about the math. So what the federal government is trying to do is have federal policy preempt state laws or federal laws preempt state laws, but maybe they can do it, maybe they can't, because it depends what states have agreed to with the Constitution. If you think about like drugs regulation, so like narcotics or something, it's similar issues to that where they're regulated federally. And so it may be the case that state and federal laws interact.
Thank you. Are there any other questions?
I'll just say too, if you see a proposed law, always check the definition section because the definition of artificial intelligence is really fluid, right? Like you'll even see vendors like rebrand something, and it may be that the way something's defined, it's not the way that you would define it if you're just thinking of that concept. I haven't read the law, but like the or the budget bill, but the definitions would be, what they're actually trying to do, like probably definition of artificial intelligence.
We have another question. Do you think that other areas of an institution beyond the library are following these issues closely? That is, could our IT groups be on top of this?
Maybe some, um, I I think in IT you'll find people can who might be following it. Remember, like libraries lead in information literacy, which is kind of bringing together like how people use information and the technology and the interface. So it might be librarians have a perspective on it to understand it more deeply. Like,
Thank you so much, Wilhelmina. This has been very, very thought-provoking, and I'm sure a lot of us will be maybe I'm speaking for myself, but I will be rereading it to digest it further, re-listening. We still
it's
have 8 minutes.
yeah, I mean it's long, but like the copyright office reports are actually really good because you could just use the table of contents and like look for what you want to see and then just read a summary that's more like pragmatically written. There were news articles like after the terminations at Library of Congress of like, oh, it's about that statement about the da licensing or whatever. But my take is actually that like I feel that the large corporations doing artificial intelligence probably just want to license from large database vendors or and then say, "Oh, that fixes other problems." Like, I don't know that it's necessarily that they're opposed to that because, they wouldn't be licensing, like, with you, they'd be licensing, like, as just a large corporate deal. Like, and then they could say, "Oh, yeah, that's all tidied up," and try to s say that it's ethical. In the regulation process, many companies making artificial intelligence system, they started, their ethical artificial intelligence department, and they'll post that information online, and it's to show that they're self-regulating so they don't get regulated by the government. And licensing might be part of that, where they just kind of welcome it as something that's real easy to do.
All righty. Thanks everyone for attending and for your great questions. There's a lot of comments. Thank you. Very interesting.
I'll also say, like librarians, we are into copyright, but also we are one of the few groups that maybe is into privacy. And so, keeping the focus on, all of fairness, accountability, transparency, and keeping grounded can help to protect patrons.
Thanks everyone. I think we can go ahead and end a few minutes early. Thanks everyone for attending NASIG. Be on the lookout for the feedback survey that will be emailed to everyone and is available on our website. We would love to hear your feedback on how we can make it better next time. So yeah, thanks.